where he litigates cases, he organizes trainings, does conferences, and he teaches. And he has litigated cases in the European Court of Human Rights, as well as Russian courts, including the Russian Supreme Court and the Russian Constitutional Court. And he's been involved in some really cool human rights cases, including most recently suing Google, which nobody ever sues Google, but he did, yeah. Right? It can be done. Okay, other issues, I'm not going to mention the names because I'll just mangle the names, but issues involve free legal aid, secret organ harvesting, rights of prisoners and their families to conjugal meetings, sex and artificial insemination. He's also authored numerous publications, including, and I got to take a look at this, How to Keep the Man Down, or Strategic Litigation of Public Interest Cases. We're going to buy that, and I'll bring it to class. Actually, I guess you can download some of it. He's also authored a chapter, The Use of European Human Rights Law in Russian Courts, and I think that was the chapter that you guys had to read. And then other books. He has received the highest legal prize in Russia, called the Femida Award for contributions toward the creation of a democratic society and the development of state legal institutions. So on that note, I'd like to welcome our guest speaker. Thank you very much.
Thank you.
And if you want them to hold their questions, just let them know, or if they can ask while you're talking.
I think it's okay if you ask, but not the very complicated questions. Questions, please leave for the end of the lecture. So thank you for this introduction. Today I would like to share with you an experience of my own experience of my colleagues from an NGO, and its experience actually for at least last 12, 14 years. But in the beginning, I will tell very quickly about the European Court of Human Rights and what kind of role does it play for a Russian lawyer, for Russian citizens. In the beginning, just a few words about Strategic Litigation Center. The idea of this non-for-profit was flying around for many years, but formally was set up just last year. And its goal is to bring and litigate cases strategically in order to help not just one client on the case, but to have a bigger impact, change the legislation or judicial practice. And second goal is to share experience that we received through different means, through media and through these kind of lectures. And sorry, I didn't tell it in the beginning. I'm translating it, broadcasting it online, so other can have a chance to see. So strategic impact litigation. Some use term strategic, some use the word impact. It aims at basically changing legal norms, practices, and have a bigger social change. And I often say that the goal of strategic litigation is not to win a case in the court of law, but to win a case in the court of mind. You really have to change the mindset of not just judges, general population, journalists, and then the change might happen in the court of law. And that's why one of the cases I will be talking about, it took 12 years to actually make a change. And the broader goal of strategic litigation that we engaged in at this center is to bring international human rights law home. It means that all these international conventions are not, particularly this European Convention for Human Rights, is not for the European Court of Human Rights. I mean, it is for the European Court, but on the first place, it's for the Russian judges to apply and for the Russian litigators, lawyers, to advance at the national level, at the national litigation. And Russia is a part of the Council of Europe since 1996. It has been 23 years just recently. Council of Europe don't don't mix it with the European Union. It's an international organization which aim at upholding human rights, democracy, rule of law, and it's done through different organs like the European Court of Human Rights, different conventions like the European Convention. It's one of many conventions that were adopted within the Council of Europe. It was founded in 1949, and it has 47 member states, including Russia. The budget is $500,000. Russia contributes quite a lot, but recently it's refused to pay. Sorry, I won't have time to go into these political details why Russia refused to pay. Here's the anthem of the European EU and the Council of Europe. It has the same flags, the same anthem. That's Beethoven Symphony. Familiar, right? And here's the hip hop version. And there are Roma versions, there are jazz versions. I spent like an hour yesterday listening, preparing for your lecture. So main organs is the Parliamentary Assembly, PASE. It's basically elected members of from different states join for sessions once in a while. Committee of Ministers is an executive body. Basically, it consists of the ministers of the foreign ministers or their deputies, and the European Court of Human Rights. And the European Court of Human Rights was established by the treaty, European Convention on Human Rights. Here's the court. Here's where the hearing took place. This is the building. It's called Human Rights Building. Quite a nice building inside, too. So what is the European Court of Human Rights? Again, it's an international court. It's based in Strasbourg, France, not Germany, as many people think. It consists of a number of judges. It's each judge from each country, a member state, but it's those judges are independent. They're not representing a state. They are elected, they're advanced by, for example, Russia, but the Parliamentary Assembly choose one judge out of 3 candidates. It's a long procedure. They sit in the individual capacity and participate in deciding cases. The court is assisted, of course, by registry, young lawyers working there. They also independent. What is the European Convention? It's an international treaty which only member states of the Council of Europe may sign, so the US cannot sign. By the way, the US has an advisory role within the Council of Europe. It can preside, it can be present at different meetings, but there's no vote. It established European Court of Human Rights, ECHR, it's abbreviation of the European Court of Human Rights. And it consists of the list of rights which are protected by the European Convention and enforced by the European Court of Human Rights. So what are the rights? It's Article 2, the right to life, freedom from torture. This is the only absolute right. There are exceptions where the right to life it does not exist, but there's no excuses for torture, for inhuman and degrading treatment. This article, torture article, includes also inhuman and degrading treatment and unusual punishment. Fair hearing, respect of private and family life, all the basic guarantees. It means that European Convention basically is not a panacea. It doesn't protect every single right on earth. It has a very limited sphere. So what does the European Court do? it applies European Convention. There are also a number of protocols which enrich the European Convention. Protocols, procedural rights, setting up procedure, applying to the European Court, and substantive rights. Basically, it decides cases on the merits. Applicants can be individuals, sometimes states. It's not very often. Happens that the state bring cases, but most cases are brought by citizens or by legal persons, like Yukos case, if you have heard of it, the oil company, Russian oil company. Judgments are binding, actually, on Russia, on many regards. A court can issue compensation. It can be from 1,000 euros to almost 2 billion euros in the Yukos case. So the government has to pay compensation, but also has to change the law, legislation, or legal practice, or judicial, administrative practice, or even medical practice. So here's the short. I can share this presentation with you later, but it's a short life of scheme of the life of the application. It can be considered by a single judge. Usually, it means that the case is not usually. It means the case is not admissible. The judge rules in admissibility decisions. Committee of 3 judges, very simple cases which on established case law. So, and then main chamber is 7 judges, consider regular cases. They can decide on inadmissibility, admissibility. Sometimes case can be assigned right away to the grand chamber, 17 judges. Sometimes chamber give up its jurisdiction in favor of grand chamber. Sometimes you can parties can sort of appeal to the grand chamber after the decision was made by the regular chamber. And then there is an execution of the judgment in the Committee of Ministers. Yes, please.
Who decides where the case goes?
When you file an application, there's a bunch of young lawyers considering whether you follow the rules of procedural rules. If it's absolutely non-admissible, it goes right here. If there are no questions about the inadmissibility, this probably will go to chamber or committee. And then it depends on merits. When can one apply to the European Court of Human Rights? When rights were violated, the rights which are in the enshrined in the European Convention. There are very complicated rules of admissibility. That's why most of the applications usually are not admissible. 95% of all the applications do not reach the stage of the judgments on the merits. And actually, it doesn't matter whether people are represented by lawyers. That's a strange statistics. But the violation has to be committed by a representative of one of the states. So you can't sue your president administration in the Russian court, or sorry, in the European Court of Human Rights, because the United States is not a member of this treaty. And the most important element that you can apply to the European Court after exhausting domestic remedies. This is one of the most important admissibility criteria. And I will speak mostly today about this criteria through 2 cases that we have been litigating for many years. So Russia joined the European Convention on May 1998. This is where Russia ratified the convention, and many lawyers actually forget that European Convention starts not with Article 2, but with Article 1, the most important article, which says, lay down a fundamental principle that states has to apply guarantees of the European Convention at their national levels, their national judicial under their jurisdiction. So first of all, European Convention has to be applied in national courts by national police. But especially in the beginning, in the 90s, in the beginning of 2000, many lawyers did not understand. They thought that, okay, Russia ratified the European Convention, now everybody has a right to apply to the European Court of Human Rights. Nobody even thought about a possibility of using guarantees of the European Convention at the national level. And especially probably because Russian lawyers are not accustomed to the idea of precedent law. It's a code law, but with some exceptions. We have the Russian Constitutional Court, we sort of use precedent law. And this is the same about the European Court. So European Convention is actually not the text of all these articles about rights. It's all about, it has this huge train of the case law starting from 70, 80. So you have to actually look at the European Convention to understand what are the guarantees. And you can use this case law when argue the case at the national level. So this is the principle that were developed by the court itself, by the Committee of Ministers, so that the effective way of implementing the convention at the national level is to actually use it at the national level, and not just the text of the convention, of course, but the case law of the European Court. That's what we have been doing for many years, and this is the attitude of judges in 2004. Just one example. This is the statement by the Chief Justice of the Regional Court, like a highest state court here. I asked this judge whether his court is organizing any trainings for lower judges on the European Convention. There has been 6 years since the ratification, and the Chief Justice said, no, we do not hold any special trainings. We don't need it. All we need is to apply national law. The funniest part of this is this press conference was called "Judges Shall Know Everything," not the European Convention, apparently. And another funny thing is that this court was to blame for one of the first judgments delivered against Russia at the European Court of Human Rights. So what kind of strategy do we use to bring down resistance to domestic direct application of the European Convention at the national court? Of course, we argue cases based on the European Convention. If we were not successful, we apply to the European Court, and we kind of package this application, and we show that judges didn't do anything, but they could. They had everything in their hands to do so. So this is kind of educating judges through litigation, through media. The most important part that we educate litigators. We share our experience through trainings. So we especially set up Ural's International Human Rights School. It's a sort of a regular training for young lawyers. And this is important because most of the cases that I will be talking about came from those lawyers who were educated, and they also engage in litigation together with us. So we publish book articles, the books that you referred today. I have them here, but they in Russian. Speaking at conference, of course. So progress. There was a very strong progress. I remember in the 1998, 99, when we would appear before the judge and will refer to the European Convention and sometimes to the case law of the European Court, and the judge may say, one more time you say a word about the European Convention, you're going to leave this room. It's not this court is not for a foreign law to argue. They have no idea that this is not a foreign law. But this has changed. now you will never hear this in court. The biggest progress was that many non-for-profits engaged this tool. They always argue their cases based on the European Convention, and therefore this gives a bigger impact on educating judges. But initially, before 2003, there were little cases where Russian Supreme Court actually referred to the European Convention. This court never referred to the case law, which means even if they refer to the European Convention, they're referring to the case law. This is not a correct way to base your judgment on the European Convention. You have to know what the case law. But today, Supreme Court and the Constitutional Court quite often come up with very good judgments. You can basically frame it and, as a good example for students to learn. And the former judge of the European Court of Human Rights, Anatoly Kovler, said he spent 12 years at the European Court, and he studied many judgments from national courts, and he come up to this conclusion: the further you are from Moscow courts, the better courts apply the European Convention. For this phrase, the head of the Moscow City Court was so much angry with the judge. But there is no progress if resolving the case according to the convention means reform of the national legislation or practices. And if the cases touch sensitive issues like transplantation, right of lifers, it means most of them are terrorists, and their family members. So I will speak about two cases. They're all about bioethical issues, and I call it laboratory work because as litigators, we were happy to get involved in these two sets of cases. It's not just two cases, it's many cases on each problem. And all of those cases, although they are different, one on secret organ harvesting, another one on the right to conjugal meetings, or rights of lifers and their family members on conjugal meetings, and artificial insemination. So absolutely different cases, but they all have similar features. These issues has never been considered by the ECHR in cases against Russia, but the same cases, very similar, were considered against other countries. So judges are more resistant to apply cases against other states, but they should. They are obliged to do so. Applicants in those cases have a case only if they argue based on the European Convention. Russian law doesn't protect them, doesn't give them any rights. If resolving case against the European, resolving the case according to the convention, it means that there should be a reform of the Russian law. And all of those cases have sensitive issues: transplantation and the right of lifers. So what strategy did you use? I sort of repeat, we would put an obvious question before the judge. So judge is like a balance, right? On one hand, we put Russian law, which does not protect the applicants. On the other hand is the European Convention, and it says the opposite. It says that the applicant has the right. And we kind of know in advance that the judges will not apply the European Convention. So we're ready to record the reaction of the judges. We sort of package it in the application to the European Court of Human Rights. So, for example, we don't just say that lack of conjugal meetings is the violation of right to private and family life, but we will also say that this is the way the judge considered the case as a violation of Article 6, which is right to fair trial. Judge absolutely ignored the European Convention. the only arguments applicants had. Then send it to the European Court, and when the ECHR comes with an evaluation of this application, so with a judgment, we come back to the national courts and try to face national judges with the European judges. So we try to make them argue with each other, not Russian judges argue with myself as a representative of the applicants, or let alone the applicants. And we engage media, we teach, and even we engage defendants to participate in conferences where we try to explain the European standards. So first case, conjugal meetings and artificial insemination. Yes, please.
Just going back to the last slide, are those intended to be in order in terms of your strategy, or are they happening simultaneously?
It depends on each case, and
okay.
It's actually a separate topic. How do we organize the litigation strategy, the litigation itself? So we call it Korolyov's case. Korolyov is a family. Veronika Korolyova, it says tired of waiting. You'll understand why. Her husband is a convicted lifer. He was convicted for terrorist attack. But I will start a little bit earlier, from 1997. That's where Russia issued a new law on rights of prisoners, and it says that there is no right to conjugal meetings for lifers for at least 10 years of their imprisonment. First 10 years, but sometimes it would be 15 years. It's not a strict time. So we had applicants similar to Korolyov. It's a family of Zakharkins, a wife and husband. Husband was convicted. It wasn't a terrorism, but he was convicted for life for attacking policemen, killing policemen. His wife was not convicted. She was normal person, citizen, law-abiding person, but they wanted to have a child. And they understood that under this law, they have no right to conjugal meeting, so there's no way to conceive a child. So we took this case, and back then it was possible to go directly to the Constitutional Court without exhausting like lower courts. And the Constitutional Court said in 2004 that a prisoner, they absolutely ignored the application coming on behalf of the wife, not a prisoner. They say the prisoner may be limited in the possibility of having a child. Later on, there was an application by Poroshenko considered by the Constitutional Court 1 year later, and it says that he may be limited in family life. So it's not enough just to limit freedom of movement, but this limitation also means limitation of the right to life, family life. So that's how we created bad precedent. Until, so we waited for many years to find other applicants. That's where Veronika Korolyova approached us in 2013. And we decided to go to district court, this time not straight to the Constitutional Court. In 2013, it was already impossible to go straight to the Constitutional Court. But unlike in Zakharkin's case, we decided, okay, so they said no to Zakharkins to conjugal meeting. So this time we will go for the right to artificial insemination. If the state does not allow natural, does not allow right to sex, does not allow to conceive a child naturally, we will ask for artificial insemination. So we went to the court and we lost it. Again, similar situation. I didn't mention this fact. Back in 2004, we didn't have any case law against any similar case law against Russia or any other member states on the right to conjugal meetings or artificial insemination. we refer to the right to family life, but based on the general case law of the European Court. But when we applied in this case to the court, we already had a precedent, Dixon versus UK, United Kingdom, where basically very similar case, two prisoners, wife and husband. The husband was convicted for life. A wife was convicted maybe for 10 years of imprisonment, and then wanted to conceive a child. And the UK ECHR ruled in 2007 in favor of the applicants that they have a right to artificial insemination, not conjugal meetings, but artificial insemination. And we use this precedent in this court. And again, the situation, Russian law has no mentioning of the right to artificial insemination. They wanted to take all the expenses on themselves. So all the state needed to do is to help to conduct this procedure, because he is serving his sentence very far away from any clinic which can do this procedure. So the state needed to transfer him from his prison, let's say, to Moscow. But they refused. And the judge weighted this precedent, said no right. And this case against the UK is not against Russia, so it's not applicable. This is actually very wrong, because the Supreme Court of Russia said even if the case is against other state, judges has to take it into account in order to prevent future violations. So, okay, when we started to exhaust the other domestic remedies, appeal, and 2 more cassations, so we can go to the European Court. And this is where Horoshenko come up. This guy who lost the case in the Constitutional Court in 2005, and his case was considered by the Grand Chamber, 17 judges of the European Court. And this case was on the right to conjugal meetings. He was not married at the time, so he asked for conjugal meetings to meet his mother and father. And he argued violation of the right to family and private life. And the European Court of Human Rights issued a judgment in favor of Horoshenko. And we were the last appeal. We took this judgment, translated it into Russian, published it in a nice-looking journal, a bulletin of the European Court of Human Rights. And Anika wrote an application to the head of the prison, asking, could you please give us a conjugal meeting based on Horoshenko versus Russia? The head of the prison said, it's not necessary, because just in 10 years you will have this right. Just wait. So we got this rejection, and we appealed this rejection in the court of law, in the district court, in 2016. And surprisingly, we won the first instance judgment. The judge actually said that this rejection by the head of the prison was wrong. He should have applied, he should have gave them the right to conjugal meeting based on Horoshenko versus Russia. But the Moscow City Court, remember the words of the judge, Kovler, the further you are from Moscow courts, the better the application. So the Moscow court quashed this judgment, and we went to the Russian Constitutional Court to argue. And we had, for the Constitutional Court, we prepared 2 sets of facts where this family was rejected the right to artificial insemination and rejected the right to conjugal meetings. And we said it was violating not only case of against the UK, but Horoshenko versus Russia. And I remember this day. This is one of the also strategy, tactics. I was sitting at the desk and thinking how I will structure the argument in the application to the Constitutional Court. And then I thought, why should I bring my their arguments to this 19 judges of the Russian Constitutional Court, let those judges argue with 17 judges of the Grand Chamber of the European Court. So I took this judgment, translated into Russian, copy and paste, literally copy and paste the arguments from the judgment into the application to the Constitutional Court, and some editing, and send it to the Constitutional Court. And surprisingly, they ruled in favor of the applicants. Yes, this is another sort of strategy. We engaged 3 more families to bring cases to the Constitutional Court for 2 reasons. One reason is that the more applicants you have, the more likely you will have 1 or 2 applicants left after some years of litigation. Some people might withdraw. And then it's more impactful when you bring more cases to the Constitutional Court, so they see that the problem exists not just with 1 family, but in many regions. So the Constitutional Court ruled there was no public hearing, unfortunately. It changed its position in the Harkin case. So 12 years ago, 12 years old opinion position was changed, absolutely reversed. They applied all the ECHR arguments, absolutely. It's beautiful judgment. You can really, I'm using it as example for my students. It directly allowed 1 conjugal meeting per year. So Anika Koroleva didn't have to wait changes of in the legislation. She could just print this judgment and go to the prison to ask for conjugal meeting. But unfortunately, this case and this part, the negative part, is not visible for those who are not involved. First of all, because there was no public hearing, the judges didn't mention the name of the NGO which took this case to the court. They didn't mention my name as a representative. And I think there is a reason for this, because if somebody, similar victims, will read the judgment, they will see the name, and then you can Google and find a lawyer. So they didn't mention this. They only considered facts on conjugal meetings. They absolutely omitted the facts which led to the right to artificial insemination, as if there was no application. They refused reconsideration of Korolev's cases. There were 2 cases, and especially the case on artificial insemination. And they only awarded legal expenses of 10,000 rubles, which is, I don't know how much is it in dollars, but it's very small. It's like 1 hour of work. And this is also a very important message that the Constitutional Court gave us. It means that if next time you will be litigating cases for 12 years and you will come to the Constitutional Court, you should know that all you're gonna get is 10,000 rubles of compensation. Yes.
Google says that's 152 US dollars.
Yeah. It's, imagine how many dollars per year of work. Well, we're going to get this compensation from the European Court of Human Rights. So the consequences of this judgment: 1,800 of lifers received the right to conjugal meetings, especially their family members. Legislation has changed, and the new dorms are being built to accommodate the visitors. Somebody told me that Poroshenko, I'm in touch with him, he said that when there was a radio in each cell, when they announced that they got a right to conjugal meetings, it was a kind of roar. Everybody really were excited about this. And Veronica went to see her husband for the first time in 10 years. She's at the airport in taking her to the airport. There are instances, Veronica told me about this, that when couple were able actually to conceive a child when having just one conjugal meeting per year. And prison doesn't really care whether the day of the 3 days of the meeting coincide with the days of the woman. But most of them are waiting for the judgment on conjugal or on artificial insemination. So why the Constitutional Court ruled in favor of these families, and why it's changed its 12 years old position? It's very difficult to convince judges that 12 years ago they were wrong. I think the Constitutional Court did not want to argue with the European Court of Human Rights. This judgment on Harashenko case was very timely. I think the Constitutional Court in this very case didn't really have a chance to rule against, not to look inhumane. And politics were involved. Just a year ago, just a year before this judgment, the Constitutional Court said that it has a jurisdiction to pick and choose European Court of Human Rights cases which are not executable in Russia. Just 6 months before Korolyov's judgment, it considered Yuka's case. Yuka's case is where the European Court said that Russia has to pay almost 2 billion euros of compensation. And the Constitutional Court said this very case is not executable in Russia. So I guess they wanted to show to the European community, to the Council of Europe, European Court, that they actually apply judgments of the European Court. Just in some cases, like Yuka's, they do not apply. So we are now waiting for the judgment of the European Court on the right to artificial insemination. There are a number of issues that it's a violation of family life, fair trial, including the behavior of the Constitutional Court that they absolutely ignored. We ask for moral damages and legal costs. I think it's very important also to, in terms of legal costs, to show the state that they have to compensate human rights lawyers as well. And we expect this judgment any day now. The European Court never set any deadlines when they're going to announce. I will only learn about the judgment day, maybe 3 weeks before. Yes?
What was the name of the case they were waiting on?
Korolyov's case.
That's the Korolyov. What's the other case? That's the other case that you were talking about, right to the conjugal.
The first one was Zakharkin's, but it's not any longer before the European Court. It wasn't considered. The Harashenko case of 2015. This is Korolyov's.
Thank you.
So the second case, where there was no happy ending yet, secret organ harvesting case, or Alina Sablina case. How many minutes do I have?
About
20. Good. So really quickly, what happened? Alina was hit by a car when crossing the street on a pedestrian zebra crossing, and she was very seriously injured, brought to the hospital. She was in a coma state. Her family members, mother and father, arrived to the hospital right away and spent 5 days at the hospital, speaking to the doctors every day, twice a day. On the 5th day, they were not allowed to enter the intensive care unit and actually see the daughter. And 6 hours later, she was pronounced dead, and they learned about this. 1 month later, mother found out, really by chance, that 6 organs were removed for transplantation. 4 out of 6 organs has disappeared. disappear, that means that there was an autopsy report that 6 organs are not in the body. But then there is a document, the list of organs removed, and this list contained only 2 organs, heart and kidney. The other organs, part of aorta, inferior vena cava, adrenal glands, and piece of lower lobe of the right lung, not recorded in the list of organs removed. Alina Sablina never expressed her willingness to be a donor. Nobody asked her, and actually it's not possible to ask right now, even today. There is no law doesn't provide to have a database of potential donors. So unlike in the US, we cannot express our wishes to be donors, like to have this mark on your driving license. And her parents were never approached to inform them that Alina is a potential donor. Never were asked whether Alina expressed any wishes before, and they didn't ask parents, do they want that Alina to be a donor? And we received this letter from the mother. So what does it mean for the mother to learn about secret harvesting of organs? For Elena Sablin, the mother, it meant that as if she buried her child for the second time, as if she learned about the death of her child for the second time. So that's inhuman treatment. So yes, this is Alina. She was 19. And we received this letter from mother. I guess she tried to attract the attention of different NGOs, human rights lawyers. Surprisingly, nobody wanted to accept this case. When we received this letter, we started to find out, you never think about this in advance. I didn't even knew that there was a law on transplantation. We read the law for the first time, and this is the Article 8 of this law. It's called Presumed Consent. And the basic meaning of it is doctors cannot remove organs if the healthcare institution at the time of removal was informed of any objections, right? Here's the key. If was informed, it's a passive role. They have to sit and wait that somebody approach the institution and inform them, no, we're against removal. But it actually never happens. It never happens because those who can inform have no idea that the transplantation, that the removal of organs is taking place, though they have no idea what to object. So this is a trap. This means that presume consent. They presume consent in every single case. In my mind, presumed consent should work that if there is a potential donor in a hospital and there are no family members and you have no chance to get in touch with them and the person is dying, then you can presume to save somebody's life. But if you have somebody present in the hospital for 5 days, approach them and ask. And surprisingly, this trap is not a secret. Doctors say about this openly. This guy, very famous doctor, anesthesiologist, right? He said, we're not required to actively ask for the consent of the relatives. So again, they sit and wait. On one hand, it's kind of understandable because these doctors, they are there to treat people, not to ask for consent. There should be a special unit, special doctor who approach relatives. But still, then I was thinking why they are so brave to say about this openly, and I found the judgment of the Constitutional Court. of 2003. It's an old case. We were not involved in this, and it says that it's inhumane to inform. It is inhumane to put the question of harvesting organs to a person relative at the same time when they learn about the death. So if you continue this thought, it's okay to remove in secret. The less you know, the better you live. But then we looked and studied the European Court of Human Rights case law, and initially there was no cases on this matter, but just before filing the case to the national courts, we found a new judgment just appeared against Latvia. And I guess Latvia had almost the same system like Russian Federation because of their roots. We all were republics of the Soviet Union. So actually there were two cases. One came after another in 2014 and 2015. And the European courts said that it's not only violation of the right to private and family life, it's also inhuman and degrading treatment to remove organs in secret. The law should be clear what is the procedure of informing relatives. So we can actually rely the defense for applicants on Article 3 and 8 of the European Convention. So you see here, there was a very clear dilemma of the local judges. They have to compare two articles. Both of them were number 8. Russian law on organ harvesting, on transplantation, and Article 8 of the European Convention, and Article 3. So we went to District Court, Moscow City Court, and then another chamber of the Moscow City Court, Supreme Court, Constitutional Court, and they all said, no, those cases are against Latvia, not against Russia, they're not applicable. I had a very strange conversation with the local judge. Already after the appeal, I happened to be in this court, and she started to talk to me. You know, you kind of get this feeling that she cares about the case. And she asked me, what are you going to do? I said, well, as we promised, we're going to go to the Constitutional Court and then to the European Court. And she said, yes, please do so. I could not rule otherwise if I was not told so from above. She didn't say what does it mean above. I guess it's the Supreme Court. So from this conversation, I gathered that she was actually willing to rule in favor of the applicants, but she had to adhere to the upper court's attitude. And all the other courts supported this ruling. So now we're waiting for the judgment of the European Court on this matter. I was told by one of the sources that it's going to be this month. But so far, the European Court didn't announce when it's going to pronounce the judgment. So we have issues: inhuman and degrading treatment, family rights, family life, fair trial. There were many violations of the right to a fair trial. If I have time, I would like to say some words about this. Prosecutor was present at the hearing. So imagine a civil case between two parties, physical persons and the legal persons, the state hospital. There's no question about, we didn't put the question whether hospitals treated the patient well enough. It was only about the question whether doctors had a chance to ask for consent, but they didn't do so. But the prosecutor was there. I objected. The judge said, no, it's fine. It's according to the law. I couldn't find this law. But the most important part is so the prosecutor appeared in one of the preliminary hearings, but then when the actual hearing started, there was no prosecutor present. I thought, wow, good, the judge listened to my motion. But then this hearing lasted for 2 days, and on the second day, there was only one part left, like final closing arguments, and the prosecutor appeared on the second day and gave her closing arguments without participating in the hearing. It's absolutely, and I know why the prosecutor was there. The judge needed the prosecutor to have its closing argument, like conclusion, to rely her judgment on her conclusions, to have some sort of a basis for the judgment. The hearing was in closed chambers. All the journalists were driven away from the courtroom. So we also say that it's a violation of fair trial. We have 2 more cases filed to the European Court on behalf of the journalists. We also represent them. So they argue based on Article 10 of the European Convention, right to access to information, right to express their opinion. Then again, moral damages and legal costs. Our next steps, we need to find more applicants on this issue, and this is a big problem because there are no applicants, simply because the entire procedure is secret, and majority of the potential applicants do not know that they buried their loved ones without organs. We intend to win the case in the European Court, then come back to the national judges and do the same thing that we did in Korolyov's case, and keep winning in the Court of Mines. Keys to success. ECHR is a very important tool to have. If there is no European Court of Human Rights, I don't know what we're going to do. And there is a possibility that Russia will be expelled from the Council of Europe, meaning from the European Convention too, this June. Not without political opportunity, like I mentioned, the UCAS case and all this. So the Constitutional Court used a smaller kind of case to show off. Media is very important, educating other lawyers. I will be talking about other similar cases, organ harvesting cases, and our organization was able to learn about those cases only because from the lawyers who underwent training that we gave, and educating judges. You see, this judge, although she ruled against Sablina, she was in favor. She wanted to rule otherwise. Oh, thank you. I think I didn't mention this. Deleted these slides because I thought we have little time. But I will say some words. There are 2 more cases on secret organ harvesting. One is before the European Court of Human Rights already. We joined this case only at the stage of the European Court. This woman, she's 85 now, mother. She was not represented, and we happened to learn from one of the participants of our training that there is a case, and we joined. And the second one is right now before the national courts in Russia. We just lost the case at the district court. I didn't expect winning this, but in order to go to the European Court of Human Rights, you have to exhaust domestic remedies. And this was an appalling hearing. It took, unlike the hearing in Sablina case, this time it took a judge just under 2 hours to consider the case. All of my motions to hear witnesses, all the doctors, transplantologists, experts were refused. Not relevant to the case. All the journalists were driven away from the courtroom. Many violations. But so after this hearing, I think if there will be another case, similar case, we will go directly to the European Court and we will argue that there is no effective domestic remedies. Why bother to exhaust? And we will be able to show this. And then, so the idea is, if Sablina case will be decided this March, we will be able to use it in our appeal in another case and do a similar thing like we did in Korolyov's case. Unfortunately, we can't ask judges of the European Court. We were asking them to speed up the process, but they said no. Thank you very much. Yes, I also use Mentimeter. You can scan this and download this book for free. It's in Russian. But if you don't speak Russian, this one is in English. This is a very expensive book, but I can share my draft chapter, which is on basically more details about these two cases that I was just saying. So I'll leave it here. Yes.
Questions? I'm wondering about the ability to subpoena records at the hospitals, and everyone knows this is like an open secret. Find other victims. Is there no way to subpoena records?
Yeah, I was raising this argument, this motion in this recent case, and the judge said no. In Alina's case, we actually had the records, medical records, and there was no problem to actually have access to it. But now it's more and more difficult. Yes.
Are there a lot of cases, like Russian cases, like get heard by the ECHR, that then they say, yes, Russia made a mistake in this way, and then the constitutional courts of Russia just don't ever take the case back or litigate it anymore?
There are different ways that when Constitutional Court can avoid hearing, like your Supreme Court, they don't have to even explain why they didn't accept the case, and it's very similar for the Constitutional Court. In terms of paying compensation, Russia is usually okay paying compensation, apart one exception, this Yuko's case. In terms of general measures like changing the legislation or changing the legal practice, it's more difficult, but it's not impossible. There are changes taking place, maybe not as fast as in Korolyov's case, like Poroshenko case 2015, and then 2016 there was already a judgment of the Constitutional Court. It's very quickly, but there's no straightforward way to the Constitutional Court. There is a provision in all the procedural codes, criminal, civil, administrative, which says that if you won the case in the European Court, you can bring a case back to the district level court. That's always happening.
So my question is a little bit of a follow-up of what you just said. So the district court then fairly routinely will then make the judgment effective without resistance, or?
The Constitutional Court?
No, the district court. So if you bring a favorable judgment back from the European Court and you bring it back into the district court, is it sort of a matter of routine, or is it just more litigation?
Again, it's not like an IT. You have the right code and everything is working. It depends on the case, on the matter of the case. Sometimes it's up to the judge. So I can't, there's no yes or no answer. You have to litigate, actually. Yes?
In the case that was decided, what was the position of the Russian judge?
In Poroshenko case, the conjugal meeting, actually it was a very good, strong position. So there were 17 judges of the Grand Chamber considering this case, and there were two opinions: Portuguese judge and the Russian judge joining the opinion. And the point was that they agreed with the majority position, but they said it's not only violation of the right to family life, but lack of conjugal meetings for 10 more years, 10 plus years, in itself is inhuman and degrading treatment, is violation of Article 3. So absolute right. There cannot be excuses saying, oh, he's a terrorist or a terrible criminal, therefore we will limit his right to access to his family. But how about family members? And it's absolute right, and that's what the judge and including Russian judge, said. That's not only private life matter, but it's about torture. It's about inhuman and degrading treatment. So this position is very, very good. And we actually used it before the Constitutional Court. Any more questions?
Well, thank you very, very much.
You're welcome.